In-person versus remote schooling during COVID-19. Is it a medical decision or an education one? In a recent case, the Ontario court faced an interesting conundrum. How should it categorize a decision on their children's schooling to be made by separated parents during COVID-19 pandemic? Was it an educational decision, or in light of the potential health risks, was it really a medical decision? The distinction was important because under a previous court-imposed parenting order, each parent in this case had a different decision-making mandate over aspects of their children's day-to-day care. Any medical decisions were left solely up to the mother, but education was an area in which both parents were to make the decision jointly. With Ontario schools to recommence classes in September 2020, the parents disagreed on how their children should participate and asked the court for a ruling. The father favored in-person learning for the children, while the mother advocated for remote learning from her home. Thus, the proper characterization of schooling question as medical or educational was a determining factor over whether both parents, or only the mother, had say in the decision. As the court explained, although not pursued in the oral submissions, the mother's written materials also advanced the position that returning to in-class learning during a pandemic is more accurately seen as a medical decision rather than an educational one. She said that these circumstances, the risk involved is akin to health assessment, and then, thus under the previous court order, the final decision is solely hers to make. The father viewed the matter differently, arguing that he trusted the risk analysis undertaken by Ontario as to the health concerns around schools reopening, and that the decision was strictly educational in nature. As the court put it, the father submitted that if it's safe for other children to go to school, it's safe for their children and their best interest to attend. The court made an initial ruling on how to properly characterize remote schooling in-person issue before deciding which of those two learning formats would serve the best interests of these children. It concluded the decision was not merely educational, but also involved the medical and physiological aspects of the children. The court elaborated by saying that it wasn't persuaded by the mother's contention that school attendance during a pandemic is a health decision that she can make alone, as opposed to an educational one which she must make together with the father. The prior court order distinguishes between the children's medical, dental, and physiological health care. The mother has final authority over non-routine medical issues, and the father makes final decisions related to non-routine dental care. However, where physiological care is the issue, paragraph 19 of the order stated that counseling or therapy requires the written consent of both parents. So whether the return to school is seen as a health decision or an educational decision, the court found it is one the parties must make together on the terms of their previous order. The tension between the children returning to in-class learning and online learning initiatives, consideration not only of their educational needs, but also their physical and physiological health needs. And so it falls to the court to determine that the parents are unable to decide the matter. So what do you think? Did the court get this right? We'll take a look at the court's particular assessment of the particular facts and outcome of this substantive ruling in an upcoming video. You can like this video, share it, subscribe. You can comment to this video at the bottom of this box. We're going to endeavor to answer everybody's questions at the end of each week. Until next time, I'm Russell Alexander.